Hi, this is Daniel Miller with NASCO, and we're still talking about the Fair Housing Act and co-ops and how your co-op can be more compliant with fair housing law. So today I want to talk a little bit about specifically the way that investigations and enforcement of the Fair Housing Act work and how somebody might find out whether or not your co-op should be further investigated if there's a complaint. Today we're going to talk a little bit about the investigations and enforcement of the Fair Housing Act and how this process works mechanically. So how does the law know? Well, usually it begins with a complaint. So maybe somebody applied to live in the co-op and their application was rejected. Or maybe they were accepted but felt that something was off about the way that process worked. Maybe somebody was asked to leave and they want to raise a complaint. Or they live in the co-op and feel that they saw something that didn't seem right, and so they made a complaint. And so the Fair Housing Act is a federal law, but usually these complaints are handled by a local agency. So that might be a local human rights commission or a landlord-tenant commission. There might be some local agency. In a big city, this is probably going to be a municipal agency that's specific to your city. It might also be a statewide agency or a regional agency, but it's not usually going to be handled by the federal government. Usually these things are delegated out, and as long as those local governments are doing all of these same things and offering the same baseline level of protection, that's how it'll generally work. Usually a complaint is going to be investigated with what they call paired testers. And so these are going to be at least two different applications to your co-op, and they're going to be very similar in most ways, but with some key differences. So for example, if somebody complained that they felt they were denied membership because of their religion, then you might have a pair of applications come in sometime in the near future where that is the main way that they differ. They have very similar applications otherwise. They answer your questions in very similar ways, but one is of this particular religious community and one is not, or of this racial background, etc. So if those paired testers come in, they're sort of secret shoppers. They'll just be normal membership applications, and your co-op isn't going to be aware that they're there as testers. But if your co-op treats those applications differently, then that local agency is going to say, it seems like there's a pattern here. Because otherwise they might just say, well, you feel you were treated discriminatorily, but you say it was because of your race, but we sent somebody in of the same racial background as you, and they got accepted as members, and then we had them back out, right? So if that local agency sends out testers and those testers were treated differently, probably that local agency is going to investigate a little bit further. That's usually going to mean they're going to contact your co-op and say that they have seen some evidence that they think suggests there's a pattern of how you're treating applications that maybe is raising some questions, and they're going to have both parties give an account of what happened. And so your co-op will be asked to explain what happened when this person applied and why you didn't accept their application or why you asked them to leave or whatever the allegation is. So you'll give the co-op's account of why this happened, and then the other party is going to say, this is what I saw. This is why I think my application was rejected, or this is why I think I was asked to move out of the co-op. Usually these complaints are going to settle out of court. It's possible that they'll go to court, but in general they're going to settle beforehand. That's usually what all parties involved want. So let me talk a little bit more about those settlements and violations. So one thing to be aware of is that violations can come with actual and punitive damages. Those could be paid by the co-op or individual directors. So an actual damage would be, I was out of a house for a month because you rejected my application and I needed a place to live. I had to spend that month living in a weekly stay motel, and it cost me $1,300 to stay in a hotel for a month, but my rent would have been $400, right? So that extra amount somebody had to pay, that's an actual damage. Or if they lost a deposit, right? So actual money that they are out as a result of the co-op's decision. But punitive damages, that's that sort of like pain and suffering that you hear people talk about. So those damages could be significantly higher. Most co-ops that are going to be interested in these trainings are going to be giving, if not explicitly affordable housing, then you're at least reasonably priced housing. But the punitive damages can be more significant. So I was humiliated, and my child was there at this meeting and we were treated disrespectfully, you know, and those things could potentially be many thousands of dollars. And when those damages come from the co-op or individual directors, that's really important. Most things that the co-op might do, the co-op is responsible for. All of you are part of the co-op, so it affects everybody. But at the end of the day, it is the co-op that is responsible for paying this bill that went unpaid, or for fixing this, you know, thing that broke because of your co-op's tree falling down on your neighbor's house. But in this case, the individual people in the co-op can be held responsible. So if one specific person in the meeting made a discriminatory statement, that person isn't protected by the co-op's corporate status. That person who made the discriminatory statement, they can be sued for making that discriminatory statement. So that's something to be aware of. You really want to be careful about understanding what it is that is or isn't appropriate as a subject for conversation. So those damages can also be related to policy. They don't have to be money damages. So some examples that attorneys have spoken to us about included having to go to specific trainings. So the co-op had to go to a training on fair housing and had to go to trainings on, you know, being inclusive of people of different racial backgrounds, or to have some training on, you know, LGBTQ issues. So it doesn't have to be about money. It can be about making sure that the co-op's policies change to prevent something like this from happening in the future. Something that we try to advise co-ops of is not to think about this as being about money. Don't assume that somebody who made a complaint is just trying to get some money out of you. Honestly, it's not usually true, and it's probably really going to influence the way that your co-op interacts with this process. So assume that if somebody makes a complaint, it's because they genuinely feel that they were treated unfairly or that something discriminatory happened. And make sure to treat that experience that they have with respect, and to go through the process in good faith and try to understand why it is that they feel this way. So the damages can also be sort of a public statement. So you might see an organization that has to publish a public retraction of their actions, or a public apology for their actions. And sometimes you see, and this is employment and not housing, but you might go into a restaurant that has that sign by the door of every one of their locations that says such and such restaurant does not hire on the basis of race and color and nationality, etc. Well, that's usually there because they were sued, and they had to put that there as part of the damages, as part of their public apology to make it right. So again, just assume that if somebody makes a complaint that they're acting in good faith, that this is a legitimate description of their experience as they've lived it, and that this is something that they are trying to prevent from happening to anybody in the future. So they see something that they think is legitimately wrong and illegal, and that they want to make sure it never happens again. The other thing is, not only your membership policies, but actually also your advertising have to comply with the Fair Housing Act. So even if you had a great process in your meetings in dealing with applications, you'll want to make sure that the advertisements themselves that you use are also as neutral and objective and factual as possible. There are also some non-obvious violations, and so it's not just about saying you can't live here. It's also about offering somebody different terms. So maybe offering a larger deposit. You require a bigger deposit from somebody because they have kids, or because they have a service animal or something like that. You also want to make sure not to offer only certain units or rooms to different people. You want to make sure to show everybody all of the possible available rooms. I would err on the side of transparency every time, that if there's a room that isn't open right now, but it will be in a month, and somebody's coming by, I would go ahead and say that right now, these are the 2 rooms that are available, but if you were interested in moving in a month from now, these other 2 rooms will also be available. And maybe I can't show you those rooms because somebody is in them and it's their private room, but I can describe it, I can show you where in the property it is, I can talk about how much it costs, I can talk about what amenities are there. So you also want to avoid using language or imagery in your ads or your tours that would discourage somebody from moving in or applying. So some of the examples that you might hear from attorneys would be, you have a leasing office where somebody comes and applies, and they come into the office and they see, a very large and prominent religious display on the wall, and they're from a religious minority and felt that they weren't welcomed there because of this, 5-foot tall wooden cross that was behind the leasing desk, as an example. So just try to be neutral and not make assumptions about who it is that should move in or who it is that will apply to move in. So steering is an example of a non-obvious kind of discrimination. So forcing a disabled person only to live in a certain area because you assume that that is where their disability limits them to, or only showing certain units, or making families with children live in one specific area. So these are all situations where you're making assumptions about how somebody uses that space, and you really want to avoid making those assumptions. Just neutrally show all of the options and let a person make a decision for themselves. It may be that you are totally right in your assumption, and that this person with a disability is uninterested in living in this room that is less accessible. But let them make that choice. Don't make it for them. So limiting and discouraging are types of discrimination. So you don't want to limit who it is that applies to the co-op for illegal reasons. You don't want to discourage people based on their protected class from coming to move in. So don't make a statement that expresses a preference based on a protected class. Don't limit somebody's ability to apply based on a protected class. And certainly don't threaten or coerce or intimidate in any way somebody who's exercising a fair housing right or helping others exercise that right. So if somebody says, I feel you're asking me to leave the co-op is discriminatory, do not escalate that situation by taking a stronger action against them or sort of hurrying the process up to get them out of the house because they're causing trouble. At that point, step back, respect their legal rights, make sure that they have the space to go through the process, and hopefully your co-op understands your legal obligations well enough that you feel confident you haven't done anything illegal, that you can show that very clearly, and that there's a misunderstanding, but that stepping back and giving people the room to go through the legal process will clear up that misunderstanding. And what's usually going to happen if your co-op is aware of these things is that you're going to be making responsible decisions, and there really is a misunderstanding. And when you get to the process and you start talking about having an investigation or having attorneys involved, the co-op can say, we're really confident that we've done the right thing and that we've done nothing illegal or discriminatory here. We're very confident explaining how it is that this works, and we're really sorry that there was a misunderstanding. And in most of those cases, this is going to get resolved in a way that is peaceful and satisfying to everybody involved, so that you can just say that there was a misunderstanding and this is what happened.